Today's topic is about challenging a will. You might want to consider doing this in two different ways. You could challenge the will of a person if you're actually questioning the validity of the will. Or you could contest a will if you've been left out of the will or treated unfairly in some way within the will. Hello, I'm Melissa, and I've been assisting clients with wills, enduring powers of attorneys and health directives for many years now. So what are some of the instances where a will can be challenged? There may be a situation where the testator, this is the person making the will, maybe lacked mental capacity to make the will, or they later revoked the will, or there are parts of the will which have been altered or additions made after the will was signed by the testator. These are instances where the validity of the will is challenged and will be determined by the court. Challenging the will involves a contest in either the Supreme or the District Courts. An application has to be made in the court, and it's called a family provision claim. Generally, testators may leave their possessions to whoever they want. If the deceased's close family members or dependents will suffer a hardship, then an application can be brought to the court for a family provision claim. This is actually governed by the Succession Act. There are strict timeframes that apply, and notice must be given within 6 months of date of death, and the actual legal proceedings must be commenced within 9 months. So who can apply? This can be a deceased spouse, child, or dependents of the deceased in order to make this application. A spouse is defined as a deceased husband or wife, de facto partner, registered partner, or former husband, wife, or registered partner. A child can actually be a biological child, a lawfully adopted child, an unborn child, or even a stepchild. A dependent could be anyone under 18 who was dependent and maintained by the deceased at the time of their death. So what does the court consider? The court considers the net value of the estate, the financial position of the applicant, the age, their sex, health of the applicant, the closeness of the relationship with the deceased, and any contributions they've made to the deceased estate over time, in addition to the character and conduct of the applicant. With respect to costs, generally the party who loses the application covers the costs. However, in some circumstances, they can be paid for by the estate. If you're in a situation and you need assistance, at Stevens & Tozer, we've assisted many clients in similar circumstances. Please contact our team on 3034 3888 or email us at any time. Thank you for listening.